In view of the foregoing discussions, we are of the humble view that the detaining authority has recorded its subjective satisfaction not only on the grounds communicated to the petitioner, but there were some other facts and relevant materials before the authority to arrive at its satisfaction. The involvement of the petitioner in 8 cases were before the detaining authority, which are likely to have influenced it in arriving at its subjective satisfaction, but the same were not mentioned in the grounds of detention. Though the detaining authority mentioned in the grounds of detention to have taken into account the involvement of the petitioner only in 3 criminal cases from 2017 to 2024. But we find that the subjective satisfaction is reached on the basis of 8 criminal cases against the petitioner instituted from 2005 to 2024. The detaining authority is not justified in taking into account the involvement of the petitioner in other 5 stale cases as spelled out in the counter affidavit, when the details of such cases have not been mentioned in the grounds of detention. Therefore, the detaining authority cannot be said to have given sufficient opportunity to the petitioner to make an effective representation. In other words, the petitioner is deprived of making an effective representation against the order of detention in compliance to the provisions of Article 22(5) of the Constitution of India, read with Section 6 of 1988 Act. The partial withdrawal of grounds of detention by not supplying all the basics and materials relied upon by the detaining authority to the petitioner shall entail the very detention in nullity for being violative of Article 22(5) of the Constitution of India. Accordingly, the detention order dated 23/7/2024 under Annexure 1 and the consequential confirmation order dated 18/10/2024 under Annexure 4 are liable to be set aside. Resultantly, the writ appeal is allowed. The impugned detention order dated 23/7/2024 under Annexure 1 and the consequential confirmation order dated 18/10/2024 under Annexure 4 are hereby set aside. The opposite parties are hereby directed to set the petitioner at liberty forthwith if he is not required to be detained in any other case.